Well, I'm happy to be able to join you in a more personal way this week, the week after you have viewed the documentary on South Africa's Truth and Reconciliation Commission. What I would like to do this week is start to introduce what I'm asking you to do in a couple of weeks. I will be asking two of you to volunteer to argue on behalf of retributive justice, two of you to argue on behalf of restorative justice, and two of you to argue for a hybrid approach to justice in this country and around the world. So that would be a retributive restorative blend. And what I would like to do today to prepare you for this debate is to talk about South Africa's Truth and Reconciliation Commission. Now, I will argue that that commission is a hybrid, retributive, restorative blend. And in a way, it's a quasi-legal approach to restorative justice. I'll go into details in a few minutes. I would like you to consider with me what would have happened if this process had been designed differently. Now, first, let me share a few of my concerns. If you've had a chance to read my B-Press article, I know that you have heard some of these concerns before. I don't think there's any harm in repeating them, emphasizing them, especially for those of you who chose to read a different article this week, and that was your choice. That's fine with me. I was initially concerned with South Africa's Truth and Reconciliation Commission. And before I go on, let me say truth and reconciliation is a form of restorative justice. Now, we have focused primarily on victim-offender mediation at the interpersonal level, at the systemic level within the criminal justice system within our country and other countries. But truth and reconciliation commissions are the primary form of restorative justice that we've seen in the world today at the international level. And they've occurred in many different conflicts, normally war-torn countries with international crimes. Argentina comes to mind immediately with their missing people during the horrendous dictatorships that they suffered under. But Indonesia is another part of the world that you can study, and of course, there's South Africa. Now, my initial concern with South Africa came when I learned that the vast majority of the people who chose to participate in the victim-offender encounter within South Africa's Truth and Reconciliation, the vast majority were Black Africans. If you know the history or even the present-day challenges of South Africa, these Black Africans who had suffered through apartheid were desperately poor, some of the poorest people in the world. And even today, South Africa is #1 of all nation states with a vast distance between the poorest and the wealthiest of their country. You've probably heard some of this analysis in recent years because the United States is unfortunately increasing its inequality, its distance between the wealthiest and the poorest. But South Africa is much worse, being at the very top of the list, even more so than Brazil, where I just spent my Fulbright Distinguished Chair, world-renowned for a distance between the wealthiest and the poorest, along with many other Latin American countries. Well, South Africa is much worse than they are. So you get a sense of my concern when I learned that the vast majority of those willing to participate in this process were Black Africans and not the white apartheid offenders. Now, I do understand giving amnesty to offenders in exchange for truth with the Truth and Reconciliation Commission, because many victims want the victim-offender encounter so they can learn the truth about what has happened to their loved ones. But I do not believe this needs to be the starting or the ending position by itself. I do believe that South Africa and other nation states have failed to understand the vast potential present with restorative justice. Let me give you some examples. Let's imagine that we had decided to do a retributive process with apartheid in South Africa. And now that we have an international criminal court, we could do a traditional retributive process. In order to learn the truth, and I know most of you, perhaps none of you, will take alternative dispute resolution with me as your faculty. So you will not have the opportunity to watch the Hollywood Academy Award-winning Erin Brockovich as an introduction to the importance of the rule of law with powerful offenders. You will also not have a chance to watch the Nuremberg trials, at least as depicted in the Hollywood classic, Judgment at Nuremberg. If you're interested in learning more about why I feel so passionately that the rule of law is appropriate in particular circumstances, you might consider viewing these films. Now, Erin Brockovich actually will start to introduce a quasi-legal, or even, it's not a hybrid restorative or retributive process, but it's a quasi-legal arbitration process, and some of the reasons to argue for a hybrid. But let me stay with the traditional retributive process. If offenders are not willing to participate, courts have the authority to subpoena witnesses so that they must present. They are asked to take an oath that they will say the truth, nothing but the truth. Now, you already know from the first weeks in this class that I am not a romantic believer in the U.S. justice system. I'm well aware of its problems. Am strongly anti-death penalty because injustice happens too often, wrongful conviction happens too often, and racism is in the heart of some of this wrongful conviction, like you saw with Hurricane Carter. That said, if you watch the Judgment at Nuremberg, you will see the importance of bringing in witnesses and exploring the truth and nothing but the truth. Too often in an informal, quasi-legal or mediation process, truth can be sacrificed for comfort. And there are cases where truth is absolutely essential. Now, on the other side, because I'm helping to prepare you for this debate, research shows that parents who raise their children with punishment as the primary method of discipline more often than not raise children who exercise violent behavior later in their life. Punishment is used to create fear, to justify negligent, absent parents, and it simply backfires in terms of parenting. But I would also argue it has backfired in terms of raising and teaching societies. If punishment, if an eye for an eye, and I'm not trying to become religious here, though maybe Desmond Tutu is coming through me. But I agree with Gandhi, if an eye for an eye is our predominant way of distributing justice, we will destroy ourselves. And that's exactly what our world is in the process of doing, what we've done for centuries. Now, Desmond Tutu did dominate this process, and I see him as a living inspiration like Gandhi or Dr. King. But he also organized the Christian religious community to influence this process. And so I imagine the legal approach or the International Criminal Court would not have been on the table. Instead, he adopted a quasi-legal approach. You notice that the purported mediators acted more like judges in questioning the offenders. And I don't have a problem with that, but to call this victim-offender encounter, at least mediated victim-offender encounter, stretches the imagination, because we really did not see the mediation that you learn in our program, and I do believe the process could have benefited from skilled mediation. We also heard a lot of psychological jargon, theories about healing from trauma through catharsis. And while I believe that emotions are, and feeling emotions are at the heart of healing trauma, I do not believe that simply feeling and expressing rage and grief shows us the best of victim-offender encounter. Now, you did see the reasons to argue for a quasi-legal process where there was somewhat of a retributive approach in having the offenders face their victims, having them experience the victim's rage and grief and all of that, learning who they had harmed. But then crossing over into the victim-offender encounter of a restorative process. So I think you're prepared to argue for a hybrid just by watching this documentary. But let me talk, before I close today, about the true victim-offender encounter when mediated by a skilled VORP or other restorative justice mediator. You did not see this here. And I have said this before, I'll say it again. No one even considered that the offender could negotiate repair of harm with the victim in this case. I don't know if you even saw extended family involved. Of course, community was welcome to observe, but they weren't intimately involved like you would see in a mediated victim-offender encounter. All of this has tremendous value. I think you've studied that enough in the course to date that I don't need to say more today. I think it's enough to encourage you to consider how this process might have been different if there were skilled mediators, if there was the victim-offender, extended family, community mediation present. And even more importantly, what I've said before, what I write about, how South Africa would be different today if the white apartheid offenders had actually invested in repairing the harm they had done to the Black African community, in helping to develop their society to reduce this distance between wealthy and poor, to develop their country in viable ways. I see a very different status quo if we would consider these options. Well, I've been happy to speak to you this week, and I look forward to doing the same next week. Have a wonderful week.